If I may ask if the senator would yield for another question?
I'd be happy to yield.
So, as I understand from your response to my last question, if you force the victims of low-dollar but multi-victim fraud to have arbitration as their only remedy, you are way less likely to get consumers asserting their rights, and ultimately you may have low-dollar, multi-consumer frauds that remain very remunerative for the crooked outfit that is conducting the massive fraud. And I get your point that the incentives are such that it's very hard for an individual consumer to be willing to pursue that claim. And if there's no way to aggregate themselves together into a class action, then there's really no way to pursue that claim. But my question goes to the second question goes to one further point, which is the power of a court in a matter like that includes the power not just to award damages, but to provide other relief, to direct the company to quit the fraud, to give orders to people to clean up their act, to promise never to do it again, and so forth. I'm not aware of any arbitration panel that has ever been given that authority or has ever used their limited power as arbiters or arbitrators to try to influence the behavior of the corporation. Is that not also a significant difference between an individual consumer being forced to go to an often stacked arbitration panel to pursue a claim that is so small it's not worth their money, and also the simple power to provide the real remedy that the public seeks, as you so wisely said, to protect the next consumer? It's not just about the people who got their pockets picked, who paid the unreasonable fee, who got defrauded. It's about stopping it so that the future consumer is protected. And I am not familiar with arbitration panels having that power.
I appreciate my colleague's question. Absolutely right. Arbitration panels do not have the power to issue injunctions. It's that simple. They do not have the power to grant injunctive relief, even in the worst of circumstances. And that is one of the reasons why forced arbitration clauses exist. There's no danger of a court ordering increased disclosure or fairer terms going forward or an end to deceptive and misleading practices. When I was Attorney General, and I see we've been joined by another of our colleagues, Senator Cronin of Texas, who served as Attorney General before he began his distinguished career here, knows well that often we as Attorneys General insisted on injunctive relief because we wanted to protect people going forward. That is a remedy that arbitration panels simply cannot award, and it is enormously consequential.
And not infrequent in class action cases.
Exactly right. Not infrequent in class action cases, not infrequent in individual cases where a plaintiff is willing to persist and takes it as a matter of principle that he will go to the nth degree legally and spend whatever it takes if he or she has the resources. And some have done it as a matter of conviction and conscience to vindicate individual consumer rights, even though their ultimate payback in monetary terms may not have actually been worth it. But injunctive relief is often the key to fairness and justice.
So fair to say in conclusion that the measure that we're about to vote on will indisputably have the effect of shifting enormous power from consumers to corporations that engage in high volume but low dollar fraud.
Exactly right. I think that is the essence of what the effect will be today of this vote if it is to roll back this rule and, in effect, enhance the overweening power of companies and corporations that force consumers to engage in arbitration that they do not know will be the result and cannot change because it is a fixed term, even though it's in the fine print, and eventually rips them off. I thank my colleague for those extraordinarily insightful questions, and I yield the floor.
Democratic leader.
Thank you, Mr. President.